The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Illinois, and we're also happy to meet with you and provide most legal services virtually.
In this video, I'm going to be talking about our third part of the three-part series on the basics of guardianship. I'm going to discuss guardianship in emergency situations, orders of protection, and how to determine if a guardianship is necessary. So, in the event of an emergency, can guardianship be used? Yes, it definitely can. A temporary guardian may be named if the court decides that emergency protection is required. If an emergency arises that necessitates the appointment of a guardian, before the guardianship petition hearing can be concluded, the court can appoint a temporary guardian before the hearing. Temporary guardianship forms are available in Cook County and a few other counties in the area, but the petitioner or his or her counsel must draft the paperwork in most cases. The court must specify what, if any, notice will be given, how it will be given, and to whom it will be given. The court can then appoint a temporary guardian who will have very clear powers and responsibilities spelled out in the order. The temporary guardianship ends when a permanent guardian is appointed, the guardianship petition is dismissed, or in 60 days, whichever comes first. Can guardianship be used along with orders of protection as a protection measure? Yes, it can. Guardianship is intended to protect the person and property of those who are unable to handle their affairs on their own, but it must be used with care. Guardianship is a type of extreme intervention in a person's life in which authority over personal and/or financial decisions is passed to someone else for an indefinite, if not always permanent, time. The law stipulates that guardianship can only be used if it will promote the well-being of the disabled individual, protect them from neglect, exploitation, and violence, and facilitate the creation of full self-reliance and independence. So how does one determine if a person requires a guardian? The presence of a mental illness does not always really imply the need for guardianship. The decisional capacity test is used to determine whether guardianship is needed. It measures a person's ability to make decisions and convey those decisions effectively. The following are some examples of practical questions that should be addressed. 1. Is the person aware that a specific decision must be made? 2. Is the individual aware of the various options available when making a decision? 3. Is the individual aware of the implications of each option? 4. Is the individual capable of informing the relevant parties after the decision has been made? Inability to make informed decisions about where to live, work, how and when to obtain medical care or other professional services, how to adequately care for dependents, and how to buy food and clothing are all signs that an individual may require guardianship services. Thanks for watching. To learn more about the basics of guardianship for incapacitated adults, check out our article links below. Be sure to leave any questions you have in the comments and subscribe for more legal content daily.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 630-324-6666. We have many locations for your convenience and we serve all of Illinois. So thanks again for watching.